So one thing I want to do is I'm going to break down all 39 claims listed in my Section 1983 complaint so you can understand how I interpret the law. I'm not a lawyer and this isn't legal advice, but that is exactly why I'm sharing it, because the court has tried to paint me as incompetent, to make me doubt the legitimacy of my case. So now I'm going to share it in the court of public opinion. I want you to be the judge. Most disturbing violations come from the North Carolina Court of Appeals. While the General Assembly refuses to investigate, the Court of Appeals is getting away with it. Here is the first unlawful order listed under Claim 15 in my complaint. The appeals process is very strict. Opposing counsel has 30 days to object to a proposed record on appeal from the date that it's served. Mr. Yap missed that deadline, so by rule, his objections could not be included. And until that record is officially docketed in the Court of Appeals, jurisdiction still belongs to the trial court or district court. That means any decisions about the proposed records have to come from district court. But instead, Mr. Yap filed in the Court of Appeals asking them to force me to accept his late objections as timely or grant him a retroactive extension. He argued that he still had time because of a 3-day mailing extension, but I didn't mail the proposed record. I served it through Odyssey, which is the trial court's or district court's electronic service system. And under Rule 5B of the North Carolina Rules of Civil Procedure, electronic service is exact. There is no extra days. But the appellate court does not use electronic service system. You can serve it through email or physically mail it, and then you will automatically get the extra 3 days extension no matter what. But the problem is that he's claiming appellate rules govern Odyssey when it does not. And Rule 25 in the appellate court states that motions that pertain to the trial court or that proposed record on appeal are governed by the North Carolina Rules of Civil Procedure, not appellate rules. Now, as for retroactive extensions, Rule 27C2 does allow them in some cases, but not for the proposed records. Rule 11 sets very hard deadlines. If you miss it, you are out. There is nothing in the rules that lets the Court of Appeals rewrite that deadline after it passes. If Mr. Yap had filed in trial court, he would have been late. So instead, he bypassed the rules and asked for the Court of Appeals to basically do him a favor. And they did. It was granted. But they failed to cite the rule that supposedly justified it. So the 3 judges did so outside their jurisdiction, interfering with my appellate and constitutional right while ignoring their own rules and case law that is clearly established. So you be the judge because they're refusing to release the names. Do you think that this order actually came from the bench? Or do you think that it could possibly be fraudulent by the clerk of the courts? Drop your ruling in the comments.